Mr. President,
The senator from Kentucky.
I suggest the absence of a quorum.
Clerk will call the roll.
Mr. Alexander.
Senators have throughout the day continued their debate on amendments to bipartisan immigration legislation, which, among other things, would provide a 13-year path to citizenship for some 11 million immigrants who are in the country illegally. Senate leaders have agreed to limit debate to 10 amendments today, but there is no timetable as of yet for votes on those amendments. Other amendments could be offered later. Majority Leader Harry Reid still looking to have the bill finished by the July 4th recess. Weekend sessions are possible in the Senate to get the bill done. And again, further amendment debate expected as the day continues here in the Senate. The Senate Commerce Subcommittee on Aviation right now convening a hearing on the proposed merger between U.S. Airways and American Airlines. U.S. Airways CEO Doug Parker and American Airlines Senior Vice President Gary Kennedy testifying today before the subcommittee on the merger, which is expected to be completed by September.
Government support. But the combination of American and U.S. Airways and the enhancement of the One World Alliance will allow us to compete more successfully in both domestic and international markets. Consumers will benefit from this enhanced competition. The new American, a better airline with a significantly expanded network on a sound financial footing, will challenge our competitors and offer the flying public more and better travel choices. The merger will join two highly complementary networks, filling critical gaps for each carrier and enabling us to bring heightened levels of service to those communities that neither airline can afford to provide on its own. We will remain committed to small and medium-sized communities. The new American Airlines will give passengers in small and medium-sized communities better connecting options and service to more places than ever before at more convenient times. Where appropriate, we expect to increase such service. The best example of our commitment to smaller communities is our service to and from the nation's capital. Because of our hub operations, U.S. Airways is able to serve 40 small and medium-sized communities from Reagan National Airport, something no other airline can or will do. I believe that great things are ahead for the new American Airlines and our employees. Our customers and the communities we serve will be the primary beneficiaries of this merger, a fact acknowledged by the civic and business leaders across our two systems.
Consent that the quorum call be rescinded.
Without objection.
Mr. President, I ask unanimous consent to set aside the pending amendments and to call my amendment number 1251.
Without objection. Clerk will report.
Senator from Texas, Mr. Cornyn, for himself and others, proposes an amendment number 1251.
Mr. President, I ask consent that the reading of the amendment be dispensed with.
Without objection.
Mr. President, I've been working on immigration policy for all the time I've been in the United States Senate, about 10 years now. So I have some familiarity with the issues and the arguments that have been made, and it's always amazing to hear a lot of the same arguments being repeated now that we've heard before in 2007 and before. But one of the differences is we have 43 senators, new senators, who weren't here in 2007, the last time we had a major debate on immigration reform. So I think the discussions have been useful, and hopefully they will be productive. But there's one obstacle, in my view, to immigration reform, which is something I would like to see. When it comes to securing our borders and making sure that the flow of illegal immigration across our borders stops or gets as close as we can to zero, the federal government has zero credibility. The reason is simple. We've been making promises since 1986 about border security and enforcement. And again, you remember that 1986 was the year that Ronald Reagan, a model of, to Republicans and conservatives, he signed an amnesty for 3 million people premised on the representation and the expectation that enforcement would ensue and the problem would be solved. In other words, he and the American people said, we'll have a compassionate resolution of the condition of the 3 million people who are here, but we want to make sure that the rule of law is restored and that we won't have to do this again. When the Gang of Eight, the 4 Republicans and 4 Democrats who authored the underlying bill, announced their product, I was hopeful they would produce a bill with solid mechanisms for gaining secure borders. Unfortunately, the bill contains no guarantees or results, no real trigger, only more promises, reminiscent of 1986 and many years subsequent. 1996, when Bill Clinton signed a law saying we're going to implement an entry-exit system, a biometric entry-exit system. When that didn't happen, after 2011, the 9/11 Commission said one of the things we need and is revealed as a vulnerability for national security is the absence of a biometric entry-exit system. But despite the passage of all those years and the recommendations of the 9/11 Commission, we still have not implemented a biometric entry-exit system. Entry system, yes, but exit, no. And 40% of illegal immigration occurs as a result of the fact that people enter the country legally and don't leave when their visa expires. So unfortunately, this bill contains more hollow promises and no real trigger. And by that I mean a conditioning on the transfer to either probationary status or to legal permanent residency based on hitting the standards that are met in the underlying bill. 100% situational awareness, 90% apprehensions, which we define in the bill, is defined in the bill as operational control of the border. So the message is, again, we don't have any enforcement mechanism here. We're going to put a lot of money, a lot of resources into this, but you know what? We can't really control what future administrations do, and we know that no current Congress can bind future Congresses, and so these promises, once again, I am very concerned, and I think the American people should be concerned, are promises only and not delivering the results that I think they insist upon before they will accept a resolution of the 11 million people in compassionate terms. But I don't think that promises alone are good enough. So you shouldn't take my word for it. You want to see, for example, what the Congressional Budget Office came out with yesterday. I think people would be serious about serious solutions to illegal immigration. But the Congressional Budget Office, which love them or hate them, agree or disagree, they are the gold standard that Congress is bound by when evaluating legislation. And what they said is the number of new unauthorized immigrants in the United States by the year 2033 will go up, it'll be 7.5 million people. If we didn't pass any bill at all, it would be 10 million. That's what the Congressional Budget Office said. That's not my figures, that's their figures. And I think it's incumbent upon anybody who disagrees to challenge these figures, and so far we've heard no challenge forthcoming. Make no mistake, border security is not an alternative to immigration reform. It is a necessary complement to the sensible reforms that I think a large majority of this chamber can agree on, such as allowing the United States to retain more highly skilled immigrants who get PhDs and master's degrees at our colleges and universities in STEM fields, science, technology, engineering, mathematics, and the like. I know there's been a fair amount of disinformation circulated about the proposals in my results amendment, so let me explain what it actually does once more. My amendment requires the federal government to have 100% situational awareness on the border. Now, with technology that the American taxpayers already paid for them, which has been deployed in Afghanistan and Iraq and owned by the Department of Defense, I'm absolutely convinced that we can get 100% situational awareness on the border. Senator McCain yesterday said he agreed with that. He cited a letter, which I'm sure we'll see forthwith, by the head of the Border Patrol, said that's attainable. Senator Bennett of Colorado, Senator Flake of Arizona, two members of the Gang of 8, they say they agree that it's attainable. I think it is attainable. That's one requirement. Secondly, my amendment requires full operational control of the border. Now, that doesn't mean 100% detentions of people coming across. It means we have a deterrent effect by at least 90% of people coming across being detained. Now, I've been in and around law enforcement most of my adult life, and it's not just how many people we detained, it's the deterrent value of the knowledge of people who violate our laws that if they do so, that they will be apprehended and they'll receive the appropriate punishment. So the deterrence factor is very important here. It's not just how many people you catch, but there has to be some metric that can be objectively measured. Next, and I alluded to this a moment ago, there has to be a nationwide biometric entry-exit system. As I said, this has been the law since 1996 when Bill Clinton signed it into law, yet it's never been implemented. What has been implemented is that when foreign nationals visit the United States, they do have to give a set of fingerprints. But there's no complementary exit system to make sure that those same people leave the country when their visa expires, whether they're a student or a tourist or a guest worker or something of the like. And that's 40% of our illegal immigration is people who enter legally and simply don't leave when their visa expires. And this biometric entry-exit system would allow us to identify them and then to allow the Department of Homeland Security and Immigration and Customs Enforcement to do their job. And fourth, my amendment requires nationwide E-Verify. In other words, it means not to make the employers the police and sort of sift through documents to try to figure out from your utility bill whether you actually are a legal resident of the United States and can qualify to work, but actually an electronic system that all employees of the federal government, all of our employees in our Senate offices have to go through anyway to make sure that this is uniformly observed so that the economic magnet that attracts so much illegal immigration is removed and that only people who can legally work in the country are allowed to do so. My amendment could have taken a much tougher position and said that the trigger must be met before people can progress or sign up for probationary status. I voted for such an amendment, but knowing that that amendment would not pass the Senate, I've said that the trigger ought to be between the probationary status and the time when people transition from probationary status to legal permanent residency. The whole rationale is not to be punitive, not to create an obstacle that can't be met, but to realign the incentives for the executive branch and the bureaucracy, for Republicans, for Democrats, for independents, for conservatives, for liberals, to come together and say we're going to make sure that this target is hit. 100% surveillance, 90% apprehensions or full operational control of the border, an E-Verify system and a biometric entry-exit system. Is it realistic to believe that these goals can be met in the next decade? Well, many experts, including members of the Gang of 8, which I mentioned a moment ago, believe it is. Some of those experts include people like Robert Bonner, the former head of Customs and Border Protection, Asa Hutchison, the former Undersecretary for Border Transportation Security at the Department of Homeland Security. And several, as I mentioned, members of the Gang of 8, Senator Bennett of Colorado, Senator Flake of Arizona, Senator McCain of Arizona, have all said they believe this requirement of 100% situational awareness and operational control of our southern border is feasible and can be accomplished, and that it's a reasonable, attainable goal. So my question for them and for others is if they believe it's attainable and if they believe that we are suffering from a trust deficit as a result of American people being asked to trust us and that trust being exploited and violated so many times in the past with promises that aren't kept, why not agree to a reasonable condition after probationary status before people transfer to legal permanent residency, where we know that the forces will be aligned in order to make sure that's met, that we can regain the American people's confidence and say we restored law and order and legality out of a current lawless and chaotic system, which exploits and preys on many innocent people who die, who are subjected to human slavery as a result of trafficking, and you name it. But there is a crisis of confidence in Washington these days, and the only way I think we're going to regain that confidence and demonstrate to the American people we're serious about making this happen is a trigger and a conditioning of that transition from RPI status to LPR status contained in my amendment. So if it's attainable and if it's something that is important in terms of regaining the public's confidence instead of just saying trust us, why not support the amendment? Why not demand real results on border security other than repetitive promises that have not been kept in the past and which the American public is in deep doubt will be kept in the future? Without a genuine border security trigger, this bill, I would dare say, Mr. President, has zero chance of passing the House of Representatives. For those of us who would like to see an improvement in the status quo, because we believe the status quo is simply unacceptable, for those of us who would like to see a good immigration reform bill passed, why not pass this bill with my amendment? Why not give this bill some momentum as it goes over to the House of Representatives and as we come together as a Senate and a House to reconcile those differences in the bill and send a good bill, an enforceable bill, not just full of hollow promises, but one that will actually gain results when it comes to security. Everybody in this chamber knows that the Senate bill is dead on arrival in the House. They have their own ideas. They're going to take up immigration reform on a piecemeal basis, but ultimately my hope is that they will cobble together one or more smaller bills, and then we'll be able to get to a conference with the House to work out the differences. But this is the kind of sleight of hand which I think undermines our credibility and increases the skepticism of the American people that we're actually going to deliver as represented when it comes to immigration reform. You've seen this before, but Senator Durbin, the distinguished majority whip, said in January 2013 a pathway to citizenship needs to be contingent upon securing the border. I agree with Senator Durbin. I agree that that is the essential bargain that the American people are willing to accept. There was a CNN poll yesterday said 6 out of 10 of the American people would accept the pathway to citizenship, perhaps grudgingly, if they actually felt like the results that they demand be provided on border security and enforcement are contained in this bill. That's why I believe it was so important for Senator Durbin to say, as part of their announcement of the goals of the Gang of Eight, that a pathway to citizenship would be contingent upon securing the border. But here's the disconnect. Unfortunately, 6 months later, June the 11th, 2013, Senator Durbin was quoted in National Journal that the gang has now decided that the pathway to citizenship and border enforcement may be delinked. In other words, the pathway to citizenship is guaranteed, and good luck on the border security and the enforcement. Good luck, present Congress, trying to enforce your will 10 years hence on a future Congress. Good luck, President Obama, trying to dictate exactly what a future president 10 years from now will do. The only way, I believe, that we can credibly go back and defend our position for immigration reform before our constituents, certainly my constituents, is to look them in the eye saying we have fixed the problem. We have done everything humanly possible to make sure that all the incentives are aligned so that border security, interior enforcement, and E-Verify are actually in place before people transition to legal permanent residency. Mr. President, we've now had 3 decades to fix our broken promises on border security, and now is the time to demand real results and to create a mechanism for achieving them. It's time to make good on our promises to the American people by securing America's borders. Mr. President, I yield the floor.
Senator from Ohio.
I rise to speak about Amendment 1311, the Hire Americans Amendment, Hire Americans First Amendment, which I hope to call up later. Nearly 8% of Americans are unemployed or underemployed, and our immigration policy obviously must be a jobs policy. Any successful immigration plan must take a closer look at the H-1B program, which serves an important but specific and limited purpose. The H-1B visa was created so businesses, particularly in high tech, but not exclusively that, so businesses could recruit foreign workers to help fill the void created by a lack of American workers with those specific skills. Yet this bill comes to the floor. As this bill comes to the floor, something very important was excluded. The bill lacks a requirement, which was in earlier versions of the bill, that employers hire an equally or better qualified American worker when one is available, rather than a potential H-1B worker. I'll repeat that. The bill lacks a requirement that employers hire a qualified, equally or better qualified American worker when one is available, rather than a potential H-1B foreign worker. With this bill, we're enshrining a process without this amendment that allows companies to pass over skilled Americans for foreign workers after they've been required to actually actively recruit those Americans. So the bill has provisions to recruit Americans for these jobs that might have gone to an H-1B foreign worker, but it falls short, doesn't require the employer to actually, after going through that process, to actually hire the American worker who is as qualified or better qualified than the H-1B foreign worker. This approach only undermines support for the H-1B program, as it will be seen as a tool to avoid hiring American workers. Understand what the American public, as they start to kind of understand and digest the provisions of this purported new law, of this legislation, when they hear that, yes, companies have to recruit and look for American workers, but in the end, even if the American worker is as qualified or more qualified, the company is under no obligation to actually hire the American. Senator Grassley has been a champion in the fight to end H-1B abuse. That is why I'm proud to join Senator Grassley in our bipartisan amendment to introduce the H-1B and L-1 Visa Fraud and Abuse Prevention Act of 2013. The H-1B program should only be used when there's no qualified worker available in the United States. That's clearly what the American people overwhelmingly say they want, that the program should only be used when there's no qualified worker available here. This amendment would increase protections to workers by requiring that employers only hire H-1B workers, as I've said before, when there's no equally qualified or better qualified American. This amendment would make sure that a worker from Wuhan won't be hired at the expense of a qualified engineer or scientist from Elyria or Sylvania, Ohio. It means ensuring that American companies seek out, find, and hire skilled American workers before seeking visas for foreign workers. But that's not included in this version, the bill we're debating on the Senate floor, in this version of the immigration bill. The bill in its current form simply says companies have to look for qualified Americans. It doesn't require them to actually hire the equally qualified or better qualified American when they find a chemist in Cleveland or a computer scientist in Salina. The underlying bill increases the number of H-1B eligible visas. That's fine. But it also cracks down on employers who take advantage of the system. But without the requirement to also hire qualified U.S. workers, the recruitment steps simply mean standing on an escalator that leads to nowhere. So again, Mr. President, what this legislation now says is that companies that want that consider H-1B visa hires need to recruit Americans, but the bill falls short of saying if the American is as qualified or more qualified, that they need to hire that American. If they're qualified Americans who can do the work, there's simply no need to fill a post with an H-1B worker. Passing this amendment, the Brown-Grassley amendment, also co-sponsored by Senator Sessions, a Republican from Alabama, and Senator Manchin, a Democrat from West Virginia. The Hire Americans First Amendment is important in fixing that. Mr. President, I yield the floor.
Mr. President.
The Senator from Oregon.
Mr. President, under the prior unanimous consent agreement, I ask to call up my amendment number 1237 as modified.
Without objection, the clerk will report the amendment.
The Senator from Oregon, Mr. Merkley, proposes amendment number 1237 as modified.
Thank you, Mr. President. I thought I'd take a few moments to just share the contents of this amendment and why it's an important addition to the bill that we're considering currently. This is related to a very critical part of Oregon's economy, which are timber jobs, forest jobs. Forest jobs have long been a pillar of our rural economy in my state. In fact, my father worked as a millwright when he first came to Oregon. He worked as a mechanic, basically keeping the sawmill operating. And when the sawmill shut down, he pursued other jobs as a mechanic. But we traveled with the timber economy, as so many families in Oregon did. And many of our rural towns are mill towns, towns closely related to the production of lumber from our national forests and from private forests. Over the past several decades, times have been pretty tough in the timber economy. And we have many forest workers who have suffered through these tough times. Their families have gone with the ups and downs of the timber economy. And certainly the recession added insult to injury, and the unemployment rates in many of our timber counties soared and have been stuck at over 15%. That's why in 2009, I and others fought to get funding in the recovery bill to expand thinning and wildfire prevention. The concept was that we have millions of acres of overgrown second growth forest that is not ideal for ecosystems. It is not ideal for producing timber. What it is ideal for are forest fires and disease. And so thinning these forests made a lot of sense, and you could put a lot of folks to work on this. Well, we did get funding for forest health, but in 2010, we had a little shock. One of our newspapers in Oregon, the Bend Bulletin, started reporting about how the Forest Service contracts intended to put Americans to work, and for the Oregon forests, Oregonians to work, were instead being awarded to contractors who were bringing in foreign workers under the H-2B visa program. These contractors, using cheap labor, were underbidding the local companies that were employing Oregonians from these rural communities, communities deeply steeped in the tradition of forest jobs. In 2011, we found out from a Department of Labor audit that some of these contracts, more than $7 million worth, not one Oregonian was hired. In fact, the audit concluded that it was likely Oregonians didn't even know the jobs existed. Now, why is that? Because the contractor, seeking to underbid the contractors who would hire Americans, proceeded to advertise in California for jobs in Oregon, proceeded to advertise well in advance of the jobs. There was a disconnect in time. Proceeded to imply in the advertisements that a second language was required. And when applications were received by the few Oregonians who found out about these jobs, they round-filed those applications. They put them through the shredder. Rather than using our tax money to thin our forests, to prevent forest fires and disease, from going to jobs here for Americans. The information provided to my office showed that in 2010 and 2011 in Oregon and Washington, more than a third of the contracts being awarded by the Forest Service were going to companies that self-attested that they couldn't find a single American worker who wanted to do these jobs. Now, these companies are operating in rural communities with very high unemployment rates in the middle of a terrible recession. And we have thousands of Oregonians who have signed up on a job seeker database saying they want to work in our forests. In Oregon, that list involves more than 5,000 individuals. 5,000 individuals who were on a state list wanting to work in the woods, and the contractors said they couldn't find anyone who wanted one of these jobs. This is exactly the type of abuse that undermines the entire program. This is a type of abuse that must not be allowed. As I go from county to county doing town halls, as I do in each county every year, folks say time and time again, we need more jobs in the woods. Well, those jobs that we do have in the woods, we may need to make sure they know about. So when our taxpayer dollars are funding the work, we need to make sure the money goes to create jobs where they're needed. And that's why I'm proposing a narrowly tailored amendment to address this problem with 3 simple changes to the H-2B program for forestry jobs. First, enhanced recruitment. Employers, before submitting a petition to hire H-2B workers, would be required to use appropriate recruitment strategies to find or notify Americans who are interested in these jobs. This could be advertising at job fairs with local and state workforce agencies and nonprofits, or advertising on reputable internet job search sites or radio. The key is that they must work with the state workforce agency to advertise in the places where local residents are likely to hear about the jobs. Exactly what did not happen in Oregon in 2009 and 2010. The second provision of this amendment is that the Secretary of Labor could grant a temporary labor certification to an employer to hire H-2B forest workers. To do that, the director of the state workforce agency would have to certify that the employer has complied with the recruitment requirements, and the director of the state workforce agency would have to make a determination that local workers were not qualified or available to fill the jobs. That way you connect the contractor who is responsible to make sure that folks know about these jobs with the workforce agency that has the expertise in finding people who want to know about these jobs. If in the situation a contractor was simply to say, well, we've advertised, we can't find anyone, the workforce agency would know whether that was a legitimate and valid conclusion. The third point is that if an employer seeks to be certified for a work itinerary that covers multiple states, and if the work outside the primary state lasts for 7 days or longer, then the employer needs to contact the agency in each state, so that you don't simply have someone starting work in California for a day or two, shifting to Oregon, shifting to Washington, shifting to Idaho, perhaps for a month in each place, but never advertising in the state where the work is being done. These are 3 simple changes to our H-2B program for forest workers that could make a real difference for individuals struggling to find work in the woods. Now, we can't go back and fix the contracts that have already been issued and abused in the past, but we can fix the problems we know about now so that those forest workers do get the jobs in the future, those Oregonians, those Americans who want to work in the woods. Let me tell you, in places like Myrtle Creek, where I was born, or Roseburg, where I went to first grade, in these timber communities, when you're born, you're practically born with a chainsaw in your hand. The timber economy is the heart of the local economy. And to have folks who are unemployed, trying to support their families, desperate for jobs in the woods, to find out that our tax money that was supposed to go to put them to work has been put to work hiring people from outside our country. That is outrageous and it's unacceptable, and this amendment will address it in a responsible manner. I urge my colleagues to support this amendment. Thank you for the time, and I yield the floor. My colleague is preparing to speak. Thank you.
President. Thank you, Mr. President. I come to the floor today to discuss H.R. 1797. A number of my colleagues, Senators Murray and Boxer, have been here this morning to talk about the bill passed yesterday in the House of Representatives that would prohibit all abortion beyond 20 weeks with very, very limited exceptions. This topic is critically important to the women of Connecticut and our country, and the bill is yet another example, lamentably and regrettably, another example of legislation that feigns concern for women's health when actually it would endanger the lives and well-being of women across this great country. The bill would take decisions regarding health care away from women and their doctors and would force the doctors to decide between incurring criminal penalties and helping their patients. That choice is unacceptable professionally and morally. The decision to have an abortion is a serious decision that a woman should make in consultation with her doctor. When those decisions are made later in a pregnancy, they most often result in serious health risks to the mother or discovery that the fetus is not viable. They are the result of those risks or the discovery that a fetus is not viable. Political interference is abhorrent and unacceptable in these personal and private decisions and violate the constitutional right of privacy. In another scenario many women may encounter if they seek an abortion later in pregnancy, the decision may be due to an inability to access services earlier, whether financial restrictions or a lack of access to health care or other extenuating circumstances. In fact, 58% of abortion patients say they would have preferred to have an abortion earlier. Low-income women were more than twice as likely than their wealthier counterparts to be delayed because of financial limitation and difficulty in making arrangements. As politicians, we should not be placing additional restrictions on women in these circumstances. The House bill blatantly ignores constitutional protections that are necessary, vitally necessary, to protect the health of women as decided in Roe v. Wade and Planned Parenthood v. Casey, because these kinds of restrictions place limitations that interfere with constitutional rights and have no place in these personal and very private decisions. The limited exceptions in this bill would require a woman to report a rape or incest to law enforcement or specific government agency when she is seeking much-needed health care services. Those restrictions affect women when they have been the victims of a crime or face serious health risks and will have no effect on reducing abortions. That's their purported purpose, to reduce abortion. But that purpose will be in no way served by these restrictions. The victims of incest or rape may be too young or too fearful of retaliation to report to a law enforcement agency. Why create a needless, lawless obstacle to vital health care? We should be working to ensure that women have the ability to access safe and affordable contraception so that there are fewer unintended pregnancies in this country. And yet, supporters of this bill would also restrict access to contraception. And they're the ones who have tried to make it more difficult to get access to the information and services necessary to prevent unintended pregnancies. We need to do more. Our nation needs to do better to ensure that women have access to preventive and maternal health care so they can be prepared to face the responsibilities of pregnancy and parenthood. This bill would do very little, if anything, to actually help women to protect their health care and the health care of their families. And so I urge my colleagues to reject any consideration of this ill-intended and I hope also ill-fated measure that endangers women's health across the country, and urge my colleagues to focus on the real priorities that face this Congress: job creation and economic recovery, for example, and stop this attack on women's health. Thank you, Mr. President, and I yield the floor. I suggest the absence of a quorum.
Clerk will call the roll.
Mr. Alexander.
With respect to the slots at DCA, Congress has always taken a very special interest in the number of slots and, the perimeter rule, and makes the decision on where.
We're all aware of that.
But in terms of the competition and the routes, and if there's competition on the routes, this is something clearly that DOJ and we at DOT took a very careful look at and is part of the analysis.
No, but I don't think you answered my.
Sorry.
That didn't answer my question at all. There is a unique relationship of an airports authority, of a compact between the federal government, the local jurisdictions, and commitments that were made that said National is going to have short haul, we're going to have a perimeter, and significant major investments from the United States government, the Commonwealth of Virginia, and the region were going to be made into Dulles because there were promises made about how perimeters and other items would be protected. Those are being, basically nicked away. My fear, of course, being that this merger may result in an effort at the next reauthorization to completely do away with the perimeter rule. And I guess I'm very, very concerned if you're simply saying on the competition standpoint that this, from the DOT role, this obligation to, that the federal government made in setting up this rather unique airport authority and commitment to Dulles is not factored in at all? Are you saying that?
What I'm saying is, Senator, is that we will look very carefully at the competition among the different airports and the like. And but in terms of slots for beyond the perimeter, that is beyond our jurisdiction because that's been determined by Congress. But in terms of competition, in terms of the routes that are being served, we will take a careful look, and we will go back and take a look at the various.
You'll look at the numbers in terms of traffic in and out of Dulles.
We will go back.
Let me get to Mr. Parker. I mean, the chairman, Chairman Rockefeller, was not here. He basically wanted to ask a similar question that everybody else had been asking. Commitments and promises were made in the last time around that there would not be this decrease to smaller markets, that some of these might be moved into Pittsburgh or elsewhere to service West Virginia. He feels that that's not happening. I want to put that on for the record. But I'd also like to ask Mr. Parker, with the idea of moving DCA into a hub, how are those costs going to be absorbed? How are those costs? Are they going to be passed on to DCA customers? Is that going to be absorbed in terms of the combined airline? Where does that kind of shake out as you think about a rethinking of DCA?
Thank you, Senator. First off, to address where Senator Rockefeller's question, I guess. You know, we have indeed heard that others have been here and made promises that people feel as though weren't kept, and are highly cognizant of that fact. All I can tell you is what I know at this point. I can't speak for where they were at that time, what they believed at that time. But because of that, what has happened in the past, and because of skepticism, therefore, about what we're saying, we're being extremely careful not to make any promises, but rather to tell people what we know at this point in time about what we believe is going to happen. And what we know is
unanimous consent that the quorum call be dispensed with.
Without objection.
Mr. President, we're debating the immigration bill again today, and as you know, I'm one of those members of the Senate who believes that our immigration system is broken, both the legal system and the way in which we deal with those who want to come here illegally. I do have concerns with the underlying legislation. I've spoken about that on the floor. I have concerns about the workplace magnet. I think the e-verification proposals in the underlying bill are an improvement on the current system, but still not as strong as they would need to be be an effective deterrent for those who are unauthorized to work. I don't think the system will work, frankly, unless we strengthen those provisions at the workplace. Most people want to come here for economic reasons, and I think if you don't deal with the workplace, you're not going to be able to affect much at the border if people really want to come here for their families and to get a job. Second, we learn now that 40% of those who are here illegally actually overstayed their visas, meaning they came here legally, but then they overstayed their visas and are here illegally now. We also learned that under e-verification, unfortunately, about 54% of those who are unauthorized to work are getting through the system now under the pilot programs that are available. So that needs to be strengthened, and I will have proposals to do that. I'm working with the 8 members of our body here who have put together this legislation and other senators on both sides of the aisle to try to strengthen those provisions, because I don't think, again, the bill is going to hold together without real enforcement. Second, I think the border enforcement needs to be strengthened, and the triggers need to be strengthened. And I'm working with Senator John Cornyn and others on that. I do hope that on both sides of the aisle we will agree that along with having workplace verification that really does determine who is eligible to work and whether the document is fraudulent or not, that we also have a secure border moving forward. Third, on the benefits side, I have concerns about some of the benefits that will be offered to people who are in this interim status, so-called RPI status, who would be in a legal status but still not receiving a green card. And so the question is, what benefits should they get? We want to be sure that people are not enticed to come here for benefits, but rather come here legally to work. But finally, I have concerns about some of the criteria for this status that would be a legal status as it relates to crimes that they have committed. And as a result, I rise today to urge my colleagues to support 2 amendments that I have filed to the underlying bill. I believe they'll serve to clarify what kinds of criminal acts would render violent offenders inadmissible under the immigration reform bill we're debating. The First Amendment addresses convictions for domestic violence, stalking, or child abuse. Under the current language, those convicted of these crimes would only be ineligible for admission in the event they served at least 1 year in prison. My amendment would change this language to declare inadmissible anyone convicted of such crimes who could have been sentenced to no less than 1 year imprisonment for the crime at the time of conviction. I think this is really a clarification amendment and a simple amendment that should be accepted by both sides, because it's in keeping with the original purpose of the language, and that's to allow a more consistent and fair application of the law. If my amendment is accepted, 2 individuals convicted of the same crime under the same circumstances would be treated in the same way under our nation's immigration laws. That's not the case as the bill is currently written. The current language puts emphasis on the time served rather than the offense committed. And as we all know, the amount of time a person convicted of a crime might serve in prison is dependent on a whole lot of factors unrelated to the purpose of this legislation, from the disposition of the sentencing judge to the recommendations made by the prosecutors to the overcrowding in many of our state prisons. So this amendment would take those extraneous considerations out of the picture, applying the same standard to all applicants for citizenship while ensuring that the spirit of the original language remains, preventing violent criminals from reaping the benefits of this legislation. The Second Amendment serves a similar purpose. It would exclude crimes against children involving moral turpitude, things like child abuse, child neglect, and contributing to the delinquency of a minor through sexual acts. It would remove those from the discretionary authority of the Secretary of Homeland Security and immigration judges with regard to removal, deportation, or inadmissibility of an individual. This amendment would strengthen our efforts to prevent and punish child abuse, and it would ensure that anyone who endangers our children is not eligible to become a citizen of this country. Mr. President, nothing's more precious than American citizenship. We see that every day with people coming to this country, some legal, some illegal. We've got to ensure this legislation does not extend that privilege to those who would commit crimes against the most vulnerable among us. These very simple, common-sense amendments would help to achieve that goal. So, along with the strengthening of E-Verify, ensuring our border will be secure, ensuring that the appropriate benefits are provided those who are not citizens but here in an interim status, I do urge my colleagues to adopt these two amendments to ensure those who would like to become citizens of the United States are those who deserve it and are not individuals who have engaged in the kind of criminal acts that would make them inappropriate to become citizens of the United States. Mr. President, I thank you, and I yield back the time. I don't see any colleagues stepping forward, so I would note the absence of a quorum.
Clerk will call the roll.
Mr. Alexander.
Does the airport have any input in this, or is it totally up to the airlines?
It's an airline decision. The airport can influence the regulator.
Thank you.
Thank you. Our 3 o'clock vote hasn't materialized, so I intend to have a second round of questions.
Good.
And so any of my colleagues who want to ask follow-up questions, please stay and do so. And I guess the good news from the first round of questioning is, in all the discussion of merger issues, the one thing that keeps popping up is slots. I think that's somewhat good news about the overall issue of the merger, but it might also not be so good news as it relates to slots, and so, or the stickiness of that issue. And this is a very, very important issue to many of my colleagues. As you can see, airports are tools for economic development, and if a community doesn't have air access, it's pretty hard to continue to grow the economic base. But Mr. Parker, when we were looking at the Modernization Act, the FAA bill, There were, U.S. Airways sought to convert 100 existing slots that you had with inside the perimeter and switch them to outside the perimeter. So you basically wanted to take DCA slots and say, okay, now let's service, you know, these farther destinations.
I ask consent to call the quorum be dispensed with.
Without objection.
Mr. President, on behalf of Senators Manchin, Pryor, and Reed of Rhode Island, I ask the following amendments be called up en bloc. Manchin number 1268, Pryor number 1298, and Reed of Rhode Island number 1224.
Without objection, clerk will report.
Senator from Vermont, Mr. Leahy, proposes amendments en bloc as follows. Manchin, 1268. Pryor, 1298. Reed of Rhode Island, 1224.
And, Mr. President, I suggest the absence of quorum.
Clerk will call the roll.
Mr. Alexander.
Senator from Iowa.
Calling the quorum be suspended.
Without objection.
Yesterday, we had the good fortune of receiving the Congressional Budget Office cost estimate of the immigration bill before the Senate, and I'd like to mention two findings from the CBO report. It will say the bill will drive down wages for legal American workers. The CBO estimates the bill would drive down their average wages. Secondly, it says the bill will not stop illegal immigration. Despite promises of a secure border, the bill would slow future illegal immigration by only 25%, according to the CBO. In the next couple of decades, that would mean 7.5 million new undocumented immigrants coming to the country. Before I dive into these two findings, let me remind my colleagues what was said by the authors of the bill. They said that undocumented immigrants and hence illegal migration would be a thing of the past. They said their bill included the toughest enforcement measures in history. In their framework, the Group of Eight said that they would write a bill, that would ensure that the problem doesn't have to be revisited. They implied that their bill, like the 1986 bill, would take care of the problems once and for all. And the obvious fact of that, the obvious fact there is that the 1986 legislation said that it would secure the border, but it never did secure the border. So we see the Group of Eight legislation before us as making the same mistakes that we made in 1986. So what the Group of Eight said, that they would write a bill that would ensure that the problem doesn't have to be revisited, we find today the Congressional Budget Office thinks entirely different. I may not always agree with CBO. I disagree with the fact that CBO has used dynamic economic effects to score this bill when they don't use it on anything else, yet they refuse to provide the dynamic scoring, particularly on revenue bills. But everyone knows what the CBO says goes. You know, I always say on the Senate floor, CBO's God. You know, they say something's going to cost something, and you want to dispute what they say, you've got to have 60 votes in this body to overturn a point of order against the CBO.
So it's very difficult to get 60 votes in the United States Senate. So that's when they say something is something, it is something, and that makes them God around this town. So I asked the proponents about these two key findings that I have pointed out. What do the proponents say about the fact that the influx of new immigrants would have the effect of bringing down average wage for American workforce? This is exactly the point that Peter Kursinow, a member of the U.S. Commission on Civil Rights, argued before our Judiciary Committee on April the 19th. He said that illegal immigration has a negative effect on the wages and employment levels of low-skilled workers, particularly African Americans. Is the fact that the second question to the group, is the fact that S-44 will drive down wages acceptable to those who support the bill. In the report, the, quote, CBO estimates that under the bill, the net annual flow of unauthorized residents would decrease by about 25% relative to what would occur under current law, end of quote. Now, I want to put in front of that 25% my own words. You mean that we pass this legislation, and according to CBO, this legislation is only going to have the effect of lowering the illegal immigration by only 25%, when we're led to believe that they're going to overcome the problems that we didn't foresee in 1986 when we legalized, thought we did it once and for all, that would take care of it. We find out now it didn't take care of it, legalized 3 million people, and now we have 12 million undocumented people here as well. So let's just see. If the CBO is correct and that the net flow of unauthorized residents would only decrease by about 25%, doesn't that indicate that we will have to revisit the immigration issue again? It is obvious that this bill won't ensure that we're not back in the same position down the road. Contrary to the promise of the Group of Eight, that we're going to write this legislation in a way that we won't have to revisit it again. We said that very same thing in 1986, but here we are 25 years later with 4 times the number of undocumented workers that we had then. The CBO also reported that while, quote, enforcement and employment verification requirements in the legislation would probably reduce the size of the U.S. population, end of quote, other aspects of the bill will, in fact, quote, probably increase the number of unauthorized residents, in particular people overstaying their visas issued under the new program for temporary workers, end of quote. This bill favors legalization before border security and apparently will have no noticeable decrease in the net annual flow of unauthorized residents. The CBO says the bill will not stop the flow of illegal immigration. If proponents are serious about stopping people from living here illegally, contrary to our law, a nation based upon the rule of law, they need to adopt common-sense legislation that will stop this flow, not merely by reducing it by just 25%. I yield the floor and